Welcome, everybody. We'll just give everyone a minute to join us. Welcome, everybody. I think we'll go ahead and get started. It's a great pleasure to be here today. I'm Jennifer Mnookin. I've got the good luck of being dean here at UCLA Law School, and thanks for being with us. Before we begin, I'd like to acknowledge that UCLA School of Law sits on the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. As members of a land-grant institution, we at UCLA pay our respects to the ancestors, elders, and relatives, past, present, and emerging. I'd like to welcome you today to the latest installation in our From the Frontline virtual series here at the law school. In these uncommonly challenging times, we're lucky here at UCLA Law School to have faculty, alums, and friends, and distinguished scholars from other institutions who are willing to join us among the foremost experts in the legal, social, and political issues that are at the heart of the current conversation. During today's panel, we'll discuss the forthcoming second impeachment trial of former President Donald Trump and its far-reaching implications. I'm absolutely thrilled to welcome our panelists, who have graciously agreed to join us as we take a closer look at this unfolding historical moment. Aziz Hook is the Frank and Bernice J. Greenberg Professor of Law at the University of Chicago Law School. He's an eminent expert in constitutional law, extremely prolific author and commentator in the field, and co-author of the book, How to Save a Constitutional Democracy. He also clerked for Justice Ruth Bader Ginsburg on the United States Supreme Court. Welcome, Aziz. My UCLA law colleague, Professor John Michaels, is another national leader in constitutional law scholarship, whose research centers on administrative law, the separation of powers, presidential power, and more. He's the author of the book, Constitutional Coup, Privatization's Threat to the American Republic, and he also clerked on the Supreme Court for Justice David Souter. Welcome, John. I'm delighted to welcome Jed Shugerman, a professor at Fordham University School of Law, and an eminent expert whose courses include administrative law and constitutional history, in which he's tremendously learned. He was a leader in the anti-corruption emoluments litigation against Trump, and he wrote the book, The People's Court, Pursuing Judicial Independence in America. Jed clerked for Judge John Walker on the Second Circuit Court of Appeals. And so, welcome, Jed. We're going to begin. I'd like to begin with a pretty broad question that gives each of our panelists a couple minutes to just help us understand what they think is most at stake in this moment, how to think about it, how we should contextualize it. Obviously, the second impeachment trial is historic, the fact that it's even happening. But how should we understand it? How can we put this into a broader context? And what aspects in each of your views might be most salient or most important? Aziz, let's start with you.
So thanks so much, Dean Mnookin, for the invitation and for the opportunity to be part of this terrific panel. I'm really grateful to be here, and I think the institution of these discussions is an important and terrific service to the UCLA community and the world. Let me try and answer the dean's question at a very high level of generality to start off with. Impeachment is a constitutional technology. It's a tool that we find in 9 out of 10 of the world's constitutions. This is a chart that shows you that only 1 in 10 constitutions, or written constitutions that have been drafted in the last 200 years, lack a provision concerning impeachment or removal. And we might ask about what to expect in the next couple of weeks by thinking, well, what is impeachment for from the perspective of its inclusion in the Constitution? So here's some data on that question from a paper that I wrote with my colleague Tom Ginsberg and David Landau that just got published in the University of Chicago Law Review. Impeachment is an instrument for addressing not just individual crimes, but also general dissatisfaction or perceptions of constitutional decline or disorder, right? And we see that in this chart, which shows you how common various grounds for impeachment are in constitutions around the world. The US Constitution, it turns out, is typical in the difficulty it creates in removing an official such as the president. This is a graphic that demonstrates or that sets out how hard it is to remove a president or a chief executive based upon the procedures and the substance of impeachment provisions in a constitution. The United States falls within the bar that's right in the middle of this chart, right? So it's the median and the modal difficulty, and it's right in the center. So the United States Constitution is actually typical of constitutions we see around the world. If we look around the world in the last 3 decades, what we see is that calls for impeachment are actually or calls for impeachment that reach some level of seriousness are not as common as you would think. There's only about 150 between 1990 and 2018. And out of those 150, only about 1 in 15, 10, actually get to the level of removal. So as a global phenomenon, removal is incredibly uncommon. This is the pattern of calls for impeachment over time. And this is my final point. This is a slide that shows you who has been impeached, which political leaders have been impeached between 1990 and 2018. And what is in common across these instances is that in all cases, the political system as a whole was in crisis. And the crisis was recognized on a cross-partisan basis. Impeachment in each of these instances was employed as a kind of reset of the political system. So the lesson to take from this highest angle view on impeachment is that it is a tool that constitutional designers have commonly included, that although it is styled as a matter of individual culpability, in fact, we see operating as a way of resetting a larger party system that has somehow hit stasis or dysfunction.
Thank you. Thank you for that really helpful context and a sense of the international dimensions as well. John, I'd love to turn to you.
Sure, and I think it's a great way to frame what's going on, to think more deeply about what's going on here. And when I think about this moment, I think about, I kind of alternate or struggle between whether our system is incredibly fragile or whether it's, there's a futility to the efforts, or there's a little of both going on. And how do I see the impeachment process working, the impeachment leading to removal and or disqualification? You know, is this a moral act, an expressive act, a political act, a legal act? And if this is what we have to go on, given the absence of alternative forms of discipline and accounting or reckoning, as Aziz was talking about, it puts a whole lot of pressure on this one instrument that really historically and comparatively really isn't used in without a great crisis surrounding it. Now, are we in a great crisis? Are we in a period of time where there needs to be a party reckoning, exactly the language that Aziz used? I think we are. I don't think the party that is perhaps most responsible for that is willing to understand the depths of the culpability and the degree to which a lot of the practices that we've seen fulfilled, whether we want to focus on what the House focused on, which was the January 6th insurrection, whether we want to focus on the call to Georgia the weekend before, whether we want to focus on revisit obstruction of justice, the Mueller investigation, Ukraine, whatever you want to do. There's a pattern in practice in which the president has seeming in some sense acted alone, but in a lot of ways through a lot of systemic enabling. I just want to focus just really quickly on the fact that if impeachment is as difficult as it's intended to be, and particularly in this moment of party polarization, the absence of alternative forms of constraint and mechanism on the modern American president are really exposed. And so in a context in which we didn't have such a powerful president, we might be able to more readily muddle through at least some of the, let's say, the excesses or some of the irresponsibilities, not necessarily all of them, but our system is in some ways maybe made sense the way it was designed, maybe made sense at the time of the founding when we had a much more narrow conception of what the power of the president would be. But particularly at this moment, even if we were to leave aside the party dynamics, the polarization dynamics, we have a potential problem with an incredibly powerful president, arguably more powerful than in many other nations, some of which don't even have presidents, and yet really weak tools to constrain that individual as the unitary executive that he historically it's only been he has embodied of late.
Thanks. That gives us some food for thought and to come back to as well. Jed, let me turn to you for some broad opening thoughts.
Great, thanks. Well, I've already learned a lot, and so I'd love to just to add a couple of thoughts. I think two main framing things are some of the errors made by both parties so far as a matter of law and or strategy. So the first thing I want to note is that one of the discouraging moments last week is that even though the Senate voted 55 to 45 that it had jurisdiction to have a trial over a former officer, the fact that it was 55-45 is, I think, discouraging as a matter of politics, as a matter of law, and as a matter of constitutional interpretation. Now, it's not an obvious, so that's the first thing I'll say is that, and then I want to focus on a legal and strategic error I think the Democrats have made. And then the final point is what the purpose of a trial may be, though we imagine that this first vote is not a sign that this is really going to have any prospect of conviction. So the error, I think, is, look, I think on the left, I think many Democrats made claims that the Constitution's text answers this question that you can have an impeachment of a former official. I think that's overstated. But I also think there's a reason why the constitutional theory doesn't lead us to be textualists about the Constitution. There's a difference between originalism and textualism. The Constitution is not meant to be like a statute. And if we are good faith originalists, and I try to be a good faith originalist, I consider myself an originalist with maybe more progressive outcomes, maybe because I think that the founders were more progressive than some of the interpreters have been over the years who claim to be originalists. But I think the original materials from 1787 help us answer this question. First, in the middle of the constitutional debates in Philadelphia, there was a global breaking news of the impeachment of a former official. His name is Warren Hastings, for conduct as an official in India. And as a former official, he stood trial, starting with returning to England in the summer of 1787, exactly when they were deliberating. And this impeachment was referred to in the convention. And if you look at the debates about impeachment, here's the remarkable thing. Several members of the convention worried explicitly about a sitting president at the end of a term manipulating the Electoral College, which in turn could provoke insurrections. Those are the words they used. And some of the framing about impeachment was very broad. So, for example, one of the delegates who became our first Attorney General said that he had been moved by impeachment to say that it was for guilt wherever found ought to be punished. They had a broad view of impeachment, and in context, even if the text doesn't answer it, I think originalists would say the materials all put together point strongly in one direction. I think it is concerning to me about constitutional interpretation that we did not have, I think, a good faith debate about those materials. On the flip side, I think the Democrats made substantial legal and strategic errors. I think to identify that the Article 1, the only article for this impeachment, is titled Incitement of Insurrection, was neither here nor there. If it was in fact incitement of insurrection, I do not understand why the Democrats waited a week to vote on it. If you really think that President Trump was inciting an insurrection, they should have voted on it or pushed it procedurally to vote on it sooner. So if you're going to make that choice, either bring an incitement of insurrection article immediately to disable a president who is doing that. Or if you're going to wait, bring a more precise and careful article. I think it is not, we do not have sufficient evidence to use this word incitement now, right? And so one perspective here is the Democrats have, whether or not you're persuaded by the, what we use these terms, incitement or aid and comfort, et cetera, I think these terms have legal meaning. And even if impeachment is political, we're asking, first of all, I think these words have meaning. And the irony is if we say that President Trump's words have meaning as insurrection, then we also, in good faith, have to say that the words we're using, or the words that Democrats or the left are using, have significant meaning. And so the caution here is that if we look at history, it's more often conservatives who criminalize speech by criminalizing terms like incitement, the Alien and Sedition Acts, that word sedition, aid and comfort, or the word treason. It is a dangerous game to use these words that criminalize conduct, and we treat speech like conduct, and it will backfire. For example, I think if we wonder about certain speakers over the past year or so who've used strong language around Black Lives Matter and other progressive causes, we have to worry about prosecutors citing this moment as precedent to criminalize the strong speech of protesters. It's I think something that is both a legal problem and a strategic problem, because it gives the gift of giving Republicans an excuse to say the facts here are strong, but I'm not going to vote for the language of insurrection. But the final point I'll say is, we haven't found enough evidence yet. The reason for a trial at this stage is not just to conclude, but also to investigate. And it is possible that that we may have a witness under oath in the next couple of weeks who goes beyond the speech involved, but actually shows some evidence of concrete conspiracy or more concrete prevention of the National Guard, which could be persuasive that this is more than speech, but was actually engaging in insurrection.
Thank you. Terrific. That was really, really interesting. I'd like to actually take some of what you've said and come back to Aziz with that. I mean, so Jed just put forward an argument that it's, in his view, relatively clear that we're supposed to think about impeachment pretty broadly, and that maybe that therefore reasonably clearly includes the ability to impeach a president that's no longer sitting, and that also that the specific article of impeachment here was too narrowly drawn. Do you agree with both of those? Would you take issue with any pieces of it? How would you, what would your additional thoughts be about those points?
I think that impeachment is one-off, but not the only one-off. The point in constitutional design and implementation where there is a very palpable slippage between law and politics. That is the process through which an outcome is to be achieved is defined by law, but where the actors responsible for implementing that procedure are unconstrained to actions within a legalistic framework and are incentivized, are pressured given their circumstances, conditions, and sources of power to respond to non-legal pressures. So I think that I'm fully subscribe to much of what Jed had to say. I do think that the breadth of impeachment as an originalist matter is usefully viewed in light of the post-ratification history through which the the idea of serious wrongdoing not necessarily attached to a criminal offense came to be viewed, even by the first half of the 19th century, as a question that had to be answered in terms of actual criminality, right? So I would add to his gloss the post-ratification history, and in particular the insistence upon the identification of a criminal offense, which I think is not necessarily supported by the founding material to which he referred. But of greater interest, perhaps given my focus upon constitutional design as a more abstract rather than legalistic matter, is the management of the gap between the legal arguments and I think what we would say in the current context, partisan or maybe hyper-partisan motives of the individuals who are charged with operationalizing those actions. And I would point to I think what I think are telling facts about that gap. The first is that the argument that I think Jed convincingly has refuted about the constitutional inability to impeach, and more relevant here, convict a past president, was made on the basis of textual grounds that, even if one doesn't think the originalist materials are important, were flimsy at best. And they were arguments that were picked up, notwithstanding the fact that they were immediately and powerfully refuted in ways that suggest that the relevant actors who picked up that argument were not interested in an argument or in the best constitutional interpretation. They were interested in the constitutional interpretation that was at least minimally plausible and that fitted their partisan agenda. I would also point out that the difficulty that we are experiencing with a politically controlled process of high-level accountability ought to be seen in contrast or in tandem with the difficulty that we saw in recent years with a more legalistic form of high-level accountability, such as the special counsel's operation over the 2017 to 2018 period, right? So we need to think about this difficulty of putting a legal decision in the hands of political partisan actors, in contrast to what happens when we put what looks like a political decision, right, whether or not a sitting president should be removed, into the hands of a legalistic actor like Robert Mueller.
Right. So there's interesting dynamics about how we think about the legal political connections and divides. John Michaels, I want to come back to you for the other piece of what Jed began to open up. In your view, should the articles of impeachment should they have been more broadly designed? And if so, what might you have wanted to see in there?
Yeah, so I guess this is in some ways this is part two of my frustration with the second round of articles of impeachment, because I also, as I alluded to, first impeachment should have had better grounds for, at the very least, inquiry on the obstruction charges. So that also was a curtailed framing. And Jed's point about having an actual opportunity for a Senate inquiry makes more sense now than it did then, given that the Democratic Party can control, presumably has at least some greater control over the scope of the inquiry, the type of hearings that could be conducted, the type of investigations. So if anything, the argument for having a more fully fleshed out, leaving the politics and the showmanship aside, just the opportunity to do that type of investigation is so much broader in this current moment than it was in the first impeachment, that we really could explore how much tampering, how much interference there was with, for instance, the Georgia proceedings, and for all we know, Pennsylvania proceedings or somewhere else as well. So I really think that the opportunity to use this space to do essentially a postmortem on what happened is really significant, because I don't think we're going to have very many other opportunities to do so. I don't know if we'll have like a 9/11 commission to figure out what's happened, in part because most of us all agreed that that was a national stress. That was a national challenge to our ability to function, our capabilities, and we're completely divided on the question whether Joe Biden actually won the election. So the opportunity to do a bipartisan inquiry of that sort in another space is absent, that we should use the impeachment and inquiry into disqualification as a potential opportunity for that. Can I just make a quick point about the Aziz's claim about legalization versus politics? I think it's an incredibly important one. And I just want to underscore that we often don't get it right. And I think that's implicit in what Aziz was saying. But if you think about the kind of the so-called prosecution of the war on terror, a lot of very political arguments were grounded and justified and kind of stripped of their moral content by reducing them to legal claims that we can do this. We can engage in enhanced interrogation. We can engage in targeted killings. We can do this, as opposed to we should. And sometimes the politicians hide behind legal claims in order to kind of distance themselves from the morality. Here, we may be cutting in the opposite direction in ways that I think unsettle Jed to an extent. But I do think this is kind of a working balance to try to negotiate this space. And frankly, I don't know if we have a rich enough discourse right now to do the type of fine parsing that I think Jed's right to be critiquing the way in which it was framed. But I don't know if they're not properly calibrating the articles of impeachment for the audience that it's intended to be delivered to. And I think that's just a challenge with the relative coarsening of our political discourse and everything else that we have to grapple with in any number of other settings as well.
Great, thank you. Speaking of audience, I want to back up for just a minute before we move forward. I want to just make sure that we get some clarity about what's at stake here with the impeachment of a former president, right? I mean, he's not in office. We did achieve a transition of power. And with the exception of what happened at the Capitol, which was certainly not peaceful, we largely achieved a peaceful transition of power. So what's at stake in terms of just being very literal? Our audience has law students, some law professors, but also some interested members of the public. Who would like to volunteer to just give us a kind of 101 on what will be different depending on the outcome of this trial, which, if that first vote means anything, maybe doesn't look terribly likely to succeed, we'll come back to that. But first, just what's at stake. Anyone want to volunteer to take that on? Jed.
Yeah, I'm happy to do so.
Perfect.
So the first step, something that John mentioned, which is really significant, is that unlike the first impeachment, where there were 53 Republicans who controlled the process and decided to have 0 witnesses. It's just remarkable. Feels like 100 years ago, but it was, think about, but nevertheless, the House was able to use hearings in the run up. Think about the timeline there from September of the whistleblower call up through that fall and into December with a vote. That was a riveting set of House hearings where a lot was revealed. And then you get to the Senate and there were no witnesses. So the key difference here is the House moved really fast, but part of the reason why they moved fast is that they knew that as of January 13th of that vote, we already knew that at a certain point, the Democrats would have 50 votes. So that's one thing that that is open is witnesses. Unclear how much Democrats want to put political capital into a long trial. And I think there are costs and benefits. But the main thing is, first of all, as you have a procedure there's a 2/3 vote for conviction. There has been some misunderstanding. Some people have suggested that, well, you could disqualify with 50 votes. That's only possible after a 2/3 conviction. And we're not going to, look, let's just be clear. It's not, unless there is some bombshell, perhaps literally a bombshell, right? That a conspiracy for a bomb or something like that. We're not going to get to the conviction, and there's not going to be a vote on disqualification. So let me say one more thing about, oh, the other procedural question is there might have been there were some reasonable interpretations that a chief justice is still supposed to preside, whether it's a president or a former president. I actually can make an originalist or purposive argument that it should be the Chief Justice, because that was among the purposes of not having the vice president preside because of a direct conflict of interest. The vice president would take the seat. I still think there is a reasonable interpretation that the same purpose applies when you're trying a former president, that it's got still political conflicts of interest, but I don't think it's clear, and I think it's fine the way they resolved it. The one more thing, Jennifer, is I think I see questions, and I think it's important to jump to what I think is an extension of this, which is people invoking the 14th Amendment, Section 3, for a disqualification, that is going to be the logical next step out of Congress if they don't get 2/3. Could there be a majority vote from both houses? And let me just quickly, this is what the 14th Amendment, Section 3, this was passed, ratified in 1868 in the wake of the Civil War to deal with the problem of former Confederates coming back into office on the federal and state level. And it allows the barring from office for anyone who, quote, engaged in insurrection or rebellion against the United States or gave aid or comfort to the enemies thereof of the United States. I just want to piggyback on some of the comments that we've already made about this, and I think it's the same concern. First of all, the advantage is the advantage of this process is also its problem. The advantage that people spot is that you could get this disqualification vote with a bare majority. That's exactly why it's dangerous, right? What's good for the goose will be good for the gander, or bad for the gander. So, but I also think as a legal matter, I still think at this moment it is an enormous stretch to say that what we know so far about Trump is engaging in insurrection, especially if we think about the Civil War as the paradigm, or giving aid or comfort. I think this is frankly, it's a bad idea to talk about this process now, unless the Senate trial or other witnesses come forward where you really have a solid case of concrete engagement.
Can I add to
Please.
what Jed said? From a more systemic perspective, the function of an impeachment is to allow the political system, a democratic political system in particular, to continue after having somehow become seized up. And from that perspective, I think it is useful to think about the impeachment, not in terms of the particular fate of former President Trump, but in terms of how it reorients the two political parties and enables healthy democratic contestation and deliberation in the future. I think that there was a moment, particularly around certain statements that then Senate Majority Leader McConnell made, when there was a sense that an impeachment process might go to, or might address, and might reorient the sensibilities of a substantial fraction of the electorate that has adopted a set of beliefs that are, I will take a stance, which I think is not controversial, which are false, and which are, through their adoption, at odds with the possibility of democratic alternation in power, right? I think that there's a substantial fraction of the public that has a set of beliefs, views about the opposing party that preclude the possibility of collaboration in the common project of democracy. If there was a moment at which one might have thought that this impeachment process, right, regardless of what it does with respect to former President Trump, which I actually think is quite secondary, if you thought that there was a moment at which it might be a pivot back for a key segment of the electorate toward a common set of standards for truth and a shared commitment to democratic contestation, I think that that hope is gone. And so, to my mind, what happens on February the 9th and how questions about evidence and the like are resolved is important only in as much as that's another point in this larger tapestry of experiences that we've had as a polity, through which the shared both beliefs about facts and shared values about the common humanity of the people on the other side of the aisle has been abandoned and might be brought back, right? And I don't, at the moment at least, and perhaps I'm being excessively cynical, I don't see how that trial, no matter what evidence it produces, is going to alter that basic fundamental problem that we are currently a democratic system with one party, the majority of the primary electorate of which does not actually commit to democracy.
A cheerful thought, right? I mean, so if that's right, I mean, if we take, if there's not a realistic possibility, barring additional future bombshells, right? I mean, I guess we could leave open the possibility that there could be evidence that emerged that would somehow matter, if evidence of some sorts perhaps could matter, I don't know. But if that's right, and there's no chance for that, and there's no chance that this will lead to conviction by a 2/3 majority, is there still sort of some demonstrative point? This comes from a question that's being asked for us by an attendee. You know, what is there potential value in a failed second impeachment attempt from the perspective of the polity? And if so, what is it? And then I want to pivot to other kinds of legal paths that might be plausible and be arising out of the events of recent months. So first, is there a point? Jed or John, would one of you like to take that on?
Yeah,
John,
I think
go ahead.
so.
I'm going to talk
Okay.
about some of the second question.
The legal
Sounds like
path.
you're
So
going
John,
to
how
the
about you
Jed,
for
you're
this
going to
one,
the
and then
big
we'll turn
board.
to Jed.
Jed, I'll talk while you work on the big board, okay? So I do think there's a point. So two things to just underscore. One is I don't think there's much of a cost, because I don't think curtailing this inquiry now would lead to good faith action the next time, at least this contingent of members, Republican members of the House and Senate will have the leadership. They will be at all reticent to pursue claims that arguably are quite threadbare. We already see there's an article of impeachment that was proposed in by a House minority member already against Biden, pretty much, I think, for showing up on his first day of office. So I'm not worried that much. I mean, this is, again, and this is not just brand new, and it's not just Trump. There were oodles of inquiries on Benghazi that made it, you know, that I could only imagine what they would be like the next time the House Republican or Jim Jordan gets a gavel. The larger point, though, I think about a historical reckoning is that this needs to be done even if it doesn't change the discourse in our generation or even the next generation. It's important to have this historical marker and to see who stood up and who didn't stand up in the face of a true threat to the stability of this country, to the integrity of the democratic processes, to the commitment to resolving differences through peaceful discourse, not through resorting to violence and bribery and anything else. And so even if this doesn't make a mark now, hopefully as a country, as a people, we're still around when our grandkids have to go back and look at this material and see what happened and understand that. It's very eye-opening to go back and read cases like Plessy versus Ferguson for our students, for Korematsu, for Dred Scott. I mean, we could say let's kind of we've passed this, we progressed past it, but there's also something about marking that and being quite surprised at how the players shook out at those moments. So Justice Black is a great civil libertarian who wrote Korematsu. How do you square that? So it's important to think about people who, there will be people whose, senators voted the wrong way on this, and they won't have an ability to vote that person out of office, but it'll be an opportunity to reckon with them. And the quickness with which we, and again, I think there are people who are already anticipating this, and this is the kind of the false cries of cancel culture. Not canceling Justice Black, we're putting Justice Black in context. Like the idea that, we can't go back and criticize and essentially morally sanction those for coming out in a way that we find abhorrent is ludicrous. This is how we progress. This is how we figure out, our moral path forward is by there's a lot of gray, but there's sometimes it's black and white, what's right and what's wrong. And I think we need to do this in order to mark this moment as not one where we all let it go, we all let it slide because it's politically expedient to move on, because there actually is a lot on President Biden's legislative agenda that needs to get done. But I think I think we need to do this too.
Great. So it's an argument that the investment now, I mean, even if it may not lead to an immediate consequence or result, that it's important for the future history, our ability to look backwards, our ability to understand, and perhaps in the doing, there may be minds that aren't changed in the moment, but that also might become changed over time and with greater space for reflection, that might create pathways for our polity that we can't fully see right now. Is that sort of?
I think we learned a certain lesson from the Clinton impeachment, and we're living with that, and we're saddled with that in some ways. And I think this will be a different moment which we live with, which is not analogous and may shift us in a different direction for a higher standard of scrutiny of the president, as it were.
Great. Well, thank you for that. I want to now turn to Jed. I'm not sure we can clearly read your chart. So
okay, let me
bring
zoom
it closer.
in. And also, go ahead, Jen.
Great. So you're going to talk to us about some of the other pathways available for dealing with this.
And I hope that if the four of us are using a lot of Zoom over the past year, but if we have some people who want to zoom in on this chart, you can change the view to speaker view from gallery, and that might be one way to
right. We also have some people who are in on the phone and probably just listening.
Got it. So I will try and verbalize this as so perfect. I have drawn a chart I'm describing here where it's a 2x3. The top is federal processes. These are all, I'm charting out what happens given that impeachment is not likely to deliver a verdict or truth, as I think Aziz and John were talking about our hopes of a process. But so what I have here is federal on top, state on bottom, and then 3 columns: legislative process, criminal process, and civil.
Great.
So the top left, federal legislative, impeachment, not likely. A trial is going to trial might produce more information, but let's not get our hopes up that it's going to be a robust process. And we've also talked about then the backup of 14th Amendment, Section 3, for arguments that, for points I think we've mentioned, it's not really suited for this. Okay. I'm going to add something else to this column, which is not directly about Trump, but it's about the legislature policing itself, Congress policing itself. Article 1, which is the article about Congress, has a section, Section 5, Clause 2, that says each house can punish, even expel by a 2/3 vote. But even if you don't have 2/3 to expel, each house can determine its rules for punishing. I think it is not a stretch to say that anyone who led the effort to overturn the election should serve on no committees. This is actually not a stretch. I mean, in fact, who was the Michigan, Justin Amash just commented yesterday that when he broke with his speaker on a vote, he was kicked off of a committee. if you can kick someone off a committee for their votes, how about voting for a coup? So I think I'm going to just put this up here as Article 1, Section 5. I think everyone, but starting with Josh Hawley and Ted Cruz, and how about the anti-Semites and QAnon conspiracy theorists like Taylor Greene and Boebert and Nazi fetishist Madison Cawthorn. Let's kick they should not be on committees in America. Okay, Krim. I think there's a real concern with relying on the Department of Justice, even a special counsel, as Aziz mentioned. I think, given that we have polarization in America, and even if Merrick Garland has a lot of respect, I think what John was saying is there's a very big agenda, not just in Congress, but for the executive branch. I think there's a real political cost to having the Department of Justice do all of these investigations, both in terms of political capital of using that, but also the polarization. I don't think it's like chanting "lock him up" or "lock her up," but we live in an environment where a president pursuing or leading or having his administration investigate and prosecute is going to get into a web of political doubt. I think one of the things that I think has been confirmed in America in this episode, the Trump era confirms federalism 1, separation of powers 0. Separation of powers failed America, to put it bluntly. But federalism and decentralized administration saved America in terms of a decentralized election. Piggybacking on that same idea, with or without pardons, right? We still have state prosecutors in the Atlanta area, and with a jury pool that is not sympathetic, right? In Manhattan. So Georgia for election fraud, and I think the case is clear, to be honest with you, at least with probable cause to get to an investigation for Georgia state law. I think it's clear enough that at least it gets you a shot. And Manhattan, insurance fraud, banking fraud. I think those are 2 examples. Then finally, on the civil side.
Wait, could you just pause on the fraud charges? You're imagining who is being charged?
On election fraud or on the Manhattan, New York?
Say a little bit. There's also a couple of questions in the chat.
So on this, I think it's the Trump organization, where if you just go back to look at what the New York prosecutors have been looking at, the tax filings, both for Trump, citizen Trump and Trump organization, may have a paper trail for felonies.
Okay, so you're imagining potentially the Trump organization, potentially Trump himself.
Both. And what Michael Cohen described in testimony before Congress was the deliberate devaluing of the property for tax purposes, and then simultaneously fraudulently registering a larger value for insurance fraud to insure property for a large value for payoff, but then paying lower taxes. So that may or may not be, we're speculating now, but that's what may be in the papers. And then finally, on the civil side, 2 examples. One, what happened on January 6th may not have been, criminal insurrection, but it could have been a tort conspiracy where we have bodily injuries for negligence cases, and it's complicated, but I think that investigation could find more concrete evidence of negligence and recklessness. And finally, the New York Attorney General, the prior New York Attorney General, used English history, used something called the writ of quo warranto manifest in New York state law to dissolve the Trump Foundation for fraud. The next step, which frankly should have been started already, but it may be in the mix for 2021, is a civil investigation by the New York Attorney General for fraud and for the emoluments, to return emoluments. And also that process can lead to the dissolving under state law of a corporation that has engaged in rampant fraud. I think I'm speculating here, but this may be the kind of investigation that could lead to the dissolution of the Trump organization.
Jennifer, may I add one thing to Jed's chart?
Please.
There will be a trial of sorts that directly concerns President Trump and will be quite consequential. That's not on Jed's chart, but it won't be a trial by either a federal or state body. It will be a trial by the so-called Facebook Supreme Court. and I should confess that some of the people on it are personal friends. I'm sure that's true for other speakers on this call, and so I need to be somewhat careful in talking about them. But I do think it is worth flagging that there is this non-state quasi-paralegal process. It's leeching its legitimacy by mimicking the forms that legitimate state action take, that is playing out on the sideline, and that will, not just because it impacts the forms of political mobilization that President Trump himself will be able to engage in, but because it will shape the forms of mobilization and networking that until now have been actually reasonably freely allowed on Facebook, that are flowing in different ways on Twitter, right? I think that there's a reasonable chance that that whatever it is that this Facebook Supreme Court does has dramatic effects upon the media ecosystem, and therefore shapes the way that the kind of inchoate group, who I think is tremendously important, which is the slice of the Republican primary electorate that believe in QAnon theories, that believe in the anti-Semitic, xenophobic, and racist accounts that are circulating about, that have circulated and will circulate about elected and unelected representatives. It shapes their world. And that intervention with respect to just President Trump is going to have, and I think it's reasonable to think, these broad systemic effects for the political system in ways I think that haven't quite been fully grasped or processed. And isn't it odd that this is this private body stacked by, I'll say, John's fellow suitor clerk's friends, that is having this effect? I'll leave John to defend the suitor clerk family.
I might defend the suitor clerk family, but I won't defend the Facebook oversight board. So if I can split that different. So I think Aziz is 100% right. And as Aziz knows, I've been kind of working on some of these issues about kind of private regulatory governance. And all I would just underscore in this particular case is that Facebook may or may not be doing the right thing at this moment, but two things. One, what did Facebook fail to do all along if it's going to be a serious, responsible actor that thinks more than just about kind of the maximization of profits, but thinks about its role in the universe, and particularly given the type of kind of rhetoric or PR that surrounds a lot of these media, these platforms. The other thing is, it just happens to be that Facebook might be kind of owning the moment in a way that, say, Mr. Pillow Company or My Pillow Company isn't. So the idea that we would rely or expect private actors to necessarily do the policing for us, it may work in this case, but there could be another moment in which corporations kind of go against free, kind of more progressive discourse. If this is not that moment, we see at least a lot of virtue signaling in support of Black Lives Matter, in support of kind of environmental concern. But I just want to walk it back and generalize it a little bit more, that this is a parallel system. It may be a parallel system that's cropping up increasingly because they think that the government system is not handling its own affairs well, so that private companies have to step in and act more kind of paternalistic. But let's just democracy deficits exist within the Senate and the Electoral College. They're probably even greater, more magnified in corporate context, and it just might be Mark Zuckerberg wants to get ahead of this.
Yeah, I mean, so it feels like we could have another entire panel on on the dimensions of the relationship between sort of big tech and democracy creation, right, or democracy harm, and maybe we should. So there may be, just stay tuned for when we invite you back for that. But I do want to take a couple of the questions, a couple additional questions from audience members before we conclude. Two people brought up additional possibilities that weren't on your chart, Jed. So I want to circle back to you and ask about, you didn't talk about Trump taxes and the sort of tax return. I guess, is that another place within the fraud space? And then what about censure? Censure as an alternative by Congress. Nobody's brought that up, and somebody asked a question about that. Does that do anything? Is that plausible? Is that, Jed, I'll start with you.
Yeah, I find censure to be just the punting on this. It has no teeth. It lets the Republicans get off the hook. And in fact, I think it is exactly when Susan Collins said, well, the House impeached Trump and now he's learned his lesson. I think that is exactly, I think it's precisely that the lesson he learned is there are no consequences. And if all they do is back into censure, then that's the same lesson that in fact Trump taught us, that Congress didn't teach Trump. Trump taught us that unless there are consequences, you're inviting more flagrant rule breaking in the future.
Aziz, John, you both agree? I see, John, you're nodding. Yeah.
Yeah, I don't have anything. I think Jed said substantially what I would.
Okay, last question. Obviously, we're a law school. All of this raises enormous sets of questions about everything from democratic structure or institutional design dimensions to legal ethics and what it means to be an ethical lawyer or member of the profession. Can each of you conclude by giving us sort of one lesson for the educational process that we could take out of this, this mess, to put not too fine a phrase on it, that might affect what we do with the curriculum. It might affect how we teach students. It might affect a course that we should make more central than it is. How should we, as an educational institution, think through some of this?
Let me jump, because it's one thing I left off the chart I thought about, and this is a good invitation to bring it back. I can name 4 lawyers, 3 of whom I knew from law school, who should be facing disbarment proceedings for their participation in things like the facilitating the cover-up of the Ukraine phone call. And I'll name the names right here: Stephen Engel, John Eisenberg, Michael Ellis. These are 3 people I knew from Yale Law School, and I worked with them and I respected them. And so what I want to highlight here is that it's what I guess is that there is a very slippery slope from saying I will be in the administration to be to be Mr. or Mrs. Anonymous. Turns out, I'll work within the administration, and lo and behold, people I knew 20 years ago as people who seem to be ethical law students, they may have committed obstruction of justice felonies. And the Nixon Watergate lawyers, 8 of them were convicted of felonies. And the same thing, at least disbarment here. And these should be trials where we teach each other about these risks. And then Jeffrey Clark, an establishment lawyer, no one would have looked at his resume and ever guessed that he would have been helping behind the scenes with a coup. These people need to be punished both for what they did and to be made examples of for the legal profession.
Aziz?
I don't disagree with anything that Jed just said, and I would fully support the proceedings, certainly in the bar, before the bar, with respect to lawyers who've either misrepresented or engaged in actions with an intent to destabilize or throw an election. But I have a different point that comes from the perspective of teaching at a law school, where I think, unlike UCLA, we have the University of Chicago is characterized by a very deep bench of students on the right as well as on the left. And so one of I feel my pedagogical obligations is finding ways to talk to students of very different political colors, including on the day of January the 6th, and trying to find things to say about what had happened. And one of the things that I have observed over the last few years is that it has become more and more difficult for students, less faculty, but certainly students of different political flags to speak to each other. And part of it is I think I've probably said enough to be clear about where my views lie. And part of it, I will say, perhaps myopically because of my own perspective, is the inability of the other side to register certain facts about the world, which I sometimes personally find difficult. I think that whether you're liberal or conservative, and whatever things you think the other side, not particular individuals, as Jed was saying, but the other side has done are objectionable. If you give up on the idea of talking to people whose views are different and objectionable to yours, you're giving up on democracy. And that's your choice at some level. You've got to choose whether you think that democracy is more important than whatever value you think is being contravened. I will say, for me, having spent a year, 2002 to 2003, living in Afghanistan, a country which didn't have democracy, a country which arguments were settled by violence, I see the real value in preserving a culture and a set of institutions through which arguments are settled through the verbal expression of differences. And that requires us all as lawyers and as human beings to be able to live with and speak to people who have deep differences from us with a measure of respect, no matter what our differences.
Thank you, Aziz. I think we're over time, and I think that's a terrific place for us to end. I want to thank all three of these distinguished professors for being with us today and for participating in what I found to be a terrific conversation. I learned a great deal. I hope our audience enjoyed it as well. Thanks very much. And we actually have another From the Front Lines session happening next week. So if you enjoyed this, please come back for more. Thanks, everybody. Take care.